In 2023, a New York lawyer filed a brief with 6 fictional case citations generated by ChatGPT. The court described it as an unprecedented circumstance. By early 2026, there are over 1,200 documented instances of AI hallucinated content submitted to courts globally. 5 to 6 new cases arrive in the database every day. What began as an embarrassment has become a profession-wide exposure, and the category of consequence has changed. This is Hallucination Files number 03. It's no longer just a fine. AI hallucinations now threaten your license. Here's what the profession is finding across every common law jurisdiction. We need to establish the scale before we get to the consequences, because the scale is part of the story. The most comprehensive tracking effort in the world is maintained by Damien Charlatan, a research fellow at HEC Paris's Smart Law Hub. As of early 2026, his database has cataloged over 1,200 cases globally in which generative AI produced hallucinated content that was submitted to courts. That database is growing at 5 to 6 new cases per day. The profession has not built the verification infrastructure to match the speed at which AI produces convincing fictions. In the United States alone, more than 200 documented incidents occurred in 2025. Across practice areas, personal injury, commercial litigation, family law, bankruptcy, employment, immigration, intellectual property, consumer protection, solo practitioners, mid-size firms, AmLaw 100 firms. This is not a technology adoption problem specific to practitioners who don't know what they're doing. It is a systematic professional failure, and the consequences are hardening in response to that scale. On June 3, 2026, 6 days before this episode, the United States Court of Appeals for the Ninth Circuit issued its ruling in LNU versus Blanche. The Ninth Circuit is the largest federal appeals court in the country. What the panel said in this ruling changes the professional landscape for every attorney working with AI. Attorneys Sethi and Rounds filed briefs in an immigration case containing multiple non-existent cases, misattributed quotations, and gross misrepresentations of real cases. The brief was produced by a person not yet licensed to practice law. No licensed attorney read the cited cases before filing. When the court identified the fabrications and issued a show cause order, the attorneys claimed the errors were typographical mistakes and repeatedly denied that generative AI had produced them. Sethi later filed a notice of errata correcting 2 citations, without disclosing anywhere in that filing that the original citations were hallucinations. The court described this as subtle subterfuge. The panel's ruling contains a sentence that every practitioner using AI needs to understand. The rules are not violated at the point of research and drafting, but at the point of signing and filing. That is the doctrinal position as of June 3, 2026, from the largest federal appeals court in the country. AI use is not the violation. Signing a filing without verifying what AI produced is the violation. The consequences in this case? Both attorneys personally suspended from practice before the Ninth Circuit for 6 months. Every attorney at their firm must include a sworn AI use statement in every filing for the next 2 years, certifying personal review of all citations and quotations. That is not a fine. That is a structural change to how a firm operates, imposed by a court for 2 years. There is a pattern across the documented cases that is worth naming explicitly, because it is the pattern that consistently produces the worst outcomes. The original hallucination, in almost every case, is the starting point. What determines the severity of the consequence is the response to being caught. In LNU versus Blanche, the attorneys had a choice at each stage of the show cause process. They chose to characterize fabricated citations as typographical errors. They chose to deny AI involvement repeatedly. When Sethi filed a correction, he described the fabricated citations as errors and incorrect, without once using the word hallucination or disclosing the AI origin. The court noticed. And the lack of candor became a separate and significant aggravating factor in the sanctions and suspension outcome. This pattern is not unique to this case. In the Oregon federal court case that resulted in $110,000 in sanctions, the attorney's response to the court's show cause order compounded the original exposure. In the Sixth Circuit case that resulted in six-figure sanctions and dismissal of the underlying matter, the response to being caught was not immediate transparency. The consistent finding across the record is this: disclosure at the first opportunity produces lighter outcomes than denial followed by forced disclosure. If a hallucination is identified by the court, by opposing counsel, or by your own review, immediate candor with the court is both the professional obligation and the practical one. The story of AI hallucinations in court filings is not a U.S. story. It is a common law story, and the direction of travel is consistent across every jurisdiction where it has emerged. In the United States, the Ninth Circuit ruling represents the clearest articulation yet of where professional liability sits. But the broader landscape includes the California State Bar's disciplinary agreement with a sanctioned attorney, a stayed one-year license suspension, plus mandatory AI ethics coursework, approved in February 2026. It includes the Oregon federal court's $110,000 sanctions order following 23 fabricated citations and 8 invented quotations. It includes the Sixth Circuit's six-figure sanctions and case dismissal. The U.S. is ahead of every other jurisdiction in documented consequences, and courts are enforcing aggressively through existing rules regardless of whether mandatory disclosure requirements are formally in place. In the United Kingdom, the trajectory is clear, even if the consequences have not yet reached the same severity. Allende v. London Borough of Haringey in 2025. Wasted costs orders, conduct described as wholly improper, referral to the Solicitor's Regulation Authority. R v. Munir v. Secretary of State in 2026. The upper tribunal treating hallucinated submissions not as isolated technical errors, but as failures of professional competence, going to the heart of the duty to the court. And Pinsent Masons, a top 20 UK firm, self-referring to the SRA after a judge criticized them for citing a fabricated statute, the third such public reprimand in months. UK firms should expect AI use disclosure obligations to harden through 2026, with growing professional conduct consequences for failure to verify before submission. In Australia, the consequences have already been applied at the license level. A lawyer stripped of his ability to practice as a principal lawyer following AI-generated false citations, September 2025. And the Federal Court of Australia went further on the language itself. In JML Rose versus Jorgensen, the court explicitly rejected the word hallucinations as language that, in the court's view, seeks to legitimize what are more properly described as fabricated, fictional, false, and fake references. That terminological position matters. Australian courts are being deliberately unsentimental about how AI errors are characterized, and that is a signal about how they will treat attempts to use AI as a mitigating explanation. The professional obligation this series has focused on so far has been the individual practitioner's obligation: the signing attorney, the filing attorney, the attorney whose name is on the brief. But in 2026, the obligation has extended upward. The UK Upper Tribunal, in R. Munir versus Secretary of State, made explicit what was previously only implied. A supervisor who fails to ensure that the work of a more junior fee earner does not contain false cases or citations is likely to be more culpable than a lawyer who fails to ensure that his own work is free from such hallucinations. Read that again. More culpable than the lawyer who made the original error. The framing inverts what most practitioners assume. The junior associate using AI is not the primary risk. The partner or supervisor who signs work produced by a junior using AI without a documented verification step is identified under this framing as potentially carrying the greater professional exposure. Allen Yu versus Blanche reinforces this from a different angle. The brief was produced by a person not yet licensed to practice law. The licensed attorneys who signed the filing had not read the cited cases. The Ninth Circuit's position was unambiguous. The signing attorney's obligation does not transfer to the person who produced the work. It remains with the signature. If you are a partner, a supervising attorney, or a managing partner whose team is using AI for research and drafting, and you do not have a documented verification protocol for that work before it reaches your signature, this episode is for you as much as it is for any junior in your firm. We're going to close the analysis with 4 obligations that are active right now. Not coming, not being considered, active. The first is the signing obligation. LNU versus Blanche is explicit. The professional obligation attaches at the point of signing and filing. If your name is on a filing, you are certifying its contents. That certification now carries documented license consequences in the Ninth Circuit and is the direction of travel in every common law jurisdiction. The second is the disclosure obligation. Multiple jurisdictions have implemented or are hardening AI use disclosure requirements in court filings. In the Ninth Circuit, firms subject to the LNU order must include sworn AI use statements in every filing for 2 years. Check your court's current requirements. This is not uniform, and it is changing. The third is the supervision obligation. Under our Munir, supervision failure in AI-assisted work may be more culpable than the underlying error. If juniors in your team are using AI for research and drafting, and you are signing their work without a documented verification step, you carry the exposure. The fourth is the candor obligation. The pattern across the record is consistent. When a hallucination is identified, immediate disclosure to the court produces materially better outcomes than characterizing the error as typographical or denying AI involvement. Lack of candor is not a neutral choice. It is an aggravating factor that courts are treating as a separate professional violation. The professional standard has not changed because the tool has. Courts are applying the same verification obligation they always have. What is new is that the consequences for failing it now include license jeopardy. That is a different category of risk from a financial sanction, and it is the category the profession is now in. The story of this series follows the same arc as the cases it covers. An unprecedented circumstance in 2023, a sanctions escalation in 2024 and 2025, and in 2026, a doctrinal shift from financial sanction to professional standing. The profession is finding this out at a pace that courts and regulators are struggling to match. The Ninth Circuit's ruling in LNU versus Blanche is 6 days old at the time this episode was produced. The SRA investigation into Pinsent Masons is ongoing. The Australian practitioner is navigating the consequences of losing his principal license. None of this is resolved. All of it is relevant to how you use AI on a matter today. We're building a practical verification system for exactly this, a complete protocol for using Claude on legal research and drafting without professional risk. More on that soon. This has been a Claude for Lawyers episode, and that's Hallucination Files number 03. See you in the next one.